Good afternoon, ladies and gentlemen. Welcome to the first inaugural Rule of Law Congress towards 2030, a decade of action for rule of law. I'm Vivian Chen, Government Counsel of the Department of Justice, and I will be your MC today. The Congress will be conducted in English with separate channels for simultaneous interpretation in Cantonese and Putonghua for online participants. Without further ado, may I first invite the Honourable Ms. Teresa Zhang, GBS SCJP, the Secretary for Justice of the Hong Kong Special Administrative Region Government, to deliver her welcome remarks. Ms. Zhang, please.
Good afternoon. Distinguished guests, ladies and gentlemen. It gives me great pleasure to welcome you to the inaugural Rule of Law Congress, which is to be held every other year in the Hong Kong Legal Week as an event of the Vision 2030 for Rule of Law. In line with the United Nations call for a decade of action to achieving Sustainable Development Goals by 2030, the theme this year is Towards 2030, a decade of action for the rule of law. Let us start with looking at the rule of law. In 2012, members of the United Nations at the high-level meeting of the 67th session of the General Assembly on the rule of law at the national and international levels adopted the declaration emphasizing on the right of equal access to justice for all and reaffirmed the commitment of member states to take all necessary steps to promote access of justice for all. And in 2015, all members in the United Nations adopted the 2030 Agenda and the 17 Sustainable Development Goals. Goal 16 recognizes the importance of the rule of law as an important pillar towards the successful implementation of 2030 Agenda. In particular, Target 16.3 promotes the rule of law at the national and international levels and ensure equal access to justice for all. At national levels, there are a number of iterations of the rule of law, and the writings and study on the subject tend to suggest that the core common denominators can be broadly categorized into formal elements, substantive elements, and procedural elements. The existence of an independent, impartial, and efficient judiciary as the procedural element is the important safeguard to ensure observance of laws by the government and the general public. A fourth category that may be relevant and worthy of further study is the cultural and level of development of the relevant jurisdiction. As noted in the UN Declaration in 2012, the rule of law and development are strongly interrelated and mutually reinforcing. As such, is it appropriate to pass judgment on the practice of the rule of law in a developing state by the same reference points as that of a developed state? Similarly, the diversity in social and legal cultures may explain why in some jurisdictions certain laws or way of dealing with a dispute is perfectly acceptable, whilst not so in others. The collection of objective data may also be a helpful and useful tool to help review the practice of the rule of law and hence to improve on it as necessary. All these will necessitate more research and study as part of the Vision 2030 project. In this inaugural Rule of Law Congress, we aim to focus on two of the factors that are crucial to access to justice: enhancing legal aid services in ensuring access to justice for all, and keeping up with the times, capacity building for judicial officers. Let me start with legal aid services. In Hong Kong, legal aid is an integral part of our legal system. At the moment, there is no ceiling on legal aid expenditure for both civil and criminal proceedings. Once the statutory means and merits tests are satisfied, legal aid funding will be available. Legal aid is available in a wide range of cases, including criminal cases, judicial review, immigration matters, torture claims, etc. Assistance schemes for eligible persons, such as the Legal Assistance Scheme for Convention Against Torture and Non-Refoulement claims, and pro bono services provided by the private sectors are also available. Statistics show that the total expenditure on legal aid cases over the past 10 years has an increase of over 230%, from 485.7 million Hong Kong dollars in 2009 and 10 to 1,133.8 million in 2019 and 2020. In a Court of Final Appeal judgment in 2018, Chief Justice Ma remarked that, as the evidence before the court showed, Hong Kong's relatively generous system of legal aid, compared with many other jurisdictions, has ensured that most cases of public importance have over the years been determined by the courts. This has also been the judiciary's experience. One of the challenges to ensuring access to justice for all is how to make effective and efficient use of resources available to provide legal aid and yet to prevent abuse. This is particularly challenging for developing countries where resources available for legal aid may be limited. We will hear how legal aid are made available in various jurisdictions and on whether legal aid should be provided in cases before international courts or tribunals, and how we could ensure access to justice even in cross-border situations, and no doubt referring to the Access to Justice Convention. Let me turn to the second topic of the day. Hong Kong's robust and independent judiciary is internationally renowned, where the World Economic Forum Global Competitiveness Report 2019 ranks Hong Kong number 2 in Asia and number 8 globally for judicial independence. Article 85 of the Basic Law also guarantees that Hong Kong courts shall exercise judicial power independently, free from any interference. Judgments of the courts are fully reasoned and available on the internet for easy access. Conflicts and disagreements on social or moral values or politics ought to be dealt with by the politicians as representatives of the people. However, in recent times, some of these issues are legalized so that they are brought before the court. The rights of an individual applicant will be adjudicated and a ruling provided. It may seem to provide a definitive answer to a specific claim, but are the underlying conflicts on the value and interests relating to the social or moral debates in the society on the issue resolved? In Madam Justice McLaughlin's words, judges no longer live in remote ivory towers. They live in the real world. Judges still speak mainly through judgments and hold themselves aloof from political controversy and social opinion. In Lord Sumption's words, if judges assert a power to give legal effect to their legal opinions and values, what is that but a claim to political power without political responsibility? I cannot wait to hear how our expert panelists would address the question of politics and law and the rigorous judicial method to be adopted in discharging judicial functions at both national and international levels. Besides having to deal with the increasingly complicated and intertwined legal and political issues, the judiciary also has to handle an unprecedented outbreak of the COVID-19 pandemic. In response to COVID-19, the Hong Kong government has supported the development of the COVID-19 online dispute resolution scheme to provide speedy and cost-effective ODR services to the general public and businesses. Hong Kong courts started to seriously review the use of technology under this new normal. We will hear from our panelists how in their jurisdictions the judiciary is catching up with the changing and challenging times and adapting to the new normal. Capacity building for judicial officers is by no means an easy subject. We hope that this session will provide a useful exchange on the topics so relevant to judicial qualities and enable us to explore how these messages can be further shared in diverse jurisdictions as part of the Vision 2030 initiative. I wish to take this opportunity to extend my sincere gratitude to the moderators and speakers, all of whom have kindly taken out time from their busy schedules to share with us their insights. A special thanks also to those participating online. But I must also express my heartfelt gratitude to members of the Task Force of Vision 2030 for Rule of Law, who are renowned members of local and international legal communities and have therefore granted us a lot of advice and guidance on taking the project of Vision 2030 for Rule of Law forward. I hope with technology, through this online arrangements, we will be able to reach out to more of you via the internet, and I hope that I will be able to see you all online for the rest of the Hong Kong Legal Week. But more importantly, I hope to see you all in Hong Kong in the Hong Kong Legal Week 2021. Thank you very much.
Thank you very much, Ms. Teresa Zhang. There will be 2 panel sessions today. If you have any questions for the speakers, please send your questions via the chat box at the Legal Week website at www.legalweek.hk, and they will be addressed at a Q&A session. For the first panel session on enhancing legal aid services in ensuring access to justice for all, we are delighted to have invited Dr. Thomas So, JP, as our moderator. Dr. So is a partner of Mayer Brown Hong Kong. He was the president of the Hong Kong Law Society from 2016 to 2018, and he has extensive experience in litigation, mediation, and arbitration with a focus of mainland matters. Dr. So, the floor is yours, please.
Welcome everyone this afternoon to join us on this session. As most of you know, that the following session we're going to talk about legal aid, and we have a few speakers to speak on the question of legal aid from their own jurisdiction. Now, as for Hong Kong, just now our Secretary of Justice has spoken on the legal aid position in Hong Kong, and I would just like to flag out, a few very important points. That as far as the provision of legal aid services in Hong Kong is concerned, we are one of the very few jurisdictions with no ceiling on legal aid expenditure for both civil and criminal proceedings, and that our legal aid expenditure per capita in 2019 and 2020 stands at 150.76 Hong Kong dollar, which is approximately 19.45 US dollar. And this is far higher than many other common law jurisdictions in the Asia-Pacific region. In addition to the conventional legal aid services that we talked about, there are also other forms of free legal services available in Hong Kong, in the form of, for example, a research center for unrepresented litigants set up by the judiciary, the Duty Lawyers Services Scheme subvented by the Hong Kong government and managed by the Hong Kong Bar Association and Hong Kong Law Society, as well as other private sector initiatives providing free legal assistance in one form or the other, provided by the legal professional bodies. So that much on legal aid services in Hong Kong. I don't want to spend any more time because our Secretary of Justice has already spoken on that topic just now. Now, without further ado, I think that we could now move on to our panel. And before we start, I would like to do a brief introduction of our speakers for this afternoon. First one, Mr. Robert Pei. Robert is the former advisor on legal affairs to Aung San Suu Kyi, and is also an advisor to her government and its justice sector after she took office in 2016. Robert was heavily involved with efforts to strengthen the legal profession in Myanmar and to improve access to justice for the population at large. He has spoken on law reform in Myanmar at events hosted by the Asian Academy of International Law, Bingham Center for the Rule of Law, Chatham House, Economist, Financial Times, Kobe University, University of Hong Kong, and U.S. Council on Foreign Relations. That is our first speaker. Our second speaker is Mrs. Adekoya. We always refer her as Funky. Now, Funky is a current member of World Bank Sanctions Board. She is a partner in the law firm in Nigeria and also in Ghana, where she heads the Dispute Resolution Practice Group. She is a past first vice president of the Nigerian Bar Association, and her responsibilities included coordinating the activities of the legal profession in the protection of human rights. She has over 40 years of experience in corporate dispute resolution and is a past vice president of the African Users Council of the London Court of International Arbitration, a governing board member and immediate past vice president of the International Council of Commercial Arbitration, the ICCA, and a member of the board of trustees of the Cairo Regional Center for International Commercial Arbitration. Our third speaker is Professor Albert Jan van den Berg, a very distinguished and well-known speaker and expert in arbitration. Professor Jan is a partner at Hanotal and van den Berg, Brussels, Belgium. He is a sought-after arbitrator in numerous international commercial and investment arbitration. He is the honorary president of the International Council for Commercial Arbitration, having served as president from 2014 to 2016. He is a visiting professor at many distinguished universities around the world. I don't want to name all of them, otherwise it would take too long. And he is an honorary president of the Netherlands Arbitration Institute. Having served as its president and secretary general and former vice president of the London Court of International Arbitration, Professor van den Berg has published extensively on international arbitration and has received numerous awards in the arbitration field. Last but not least, Mr. Hans van Loon. Mr. van Loon is the former Secretary General of the Hague Conference on Private International Law and a member of the Institute Detroit International. As Secretary General, he steered the conference through a period of rapid expansion of its membership, including that of the European Union and of states party to the Hague Conventions, as well as establishing regional offices all around the world, including for the Asia-Pacific region here in Hong Kong. Mr. van Loon has been involved in the development of over a dozen Hague Conventions as well as the revision of the conference statute. He has lectured worldwide and widely published on numerous topics of private international law, and I understand Mr. van Loon later on is going to talk about the conventions to us, so I really look forward to that. So without further ado, allow me to first introduce Mr. Robert Pei. I understand that Robert is going to talk to us about legal aid in Myanmar. Robert, over to you.
Hello, Thomas. Can I check that you can hear me clearly?
I can hear you loud and clear.
Yes, thank you. We have had some technical issues, so the panelists can hear the technical support team talking, which I don't know if someone could please mute, because otherwise it's very distracting for us. So if the IT support team could please mute.
Right, okay. Yeah, got it.
Thank you. So I will talk a little about giving access to justice in Myanmar. There's a very nascent legal aid system, which I'll come on to, but I'm going to start more broadly by setting the scene. Before I do that, I must thank the Department of Justice and the other organisers for inviting me to join you today. It's a great privilege to be with you. And as many of you know, I lived in Hong Kong for 2 decades and I'm very much missing Hong Kong. So it's good to reconnect with everyone. I hope that you can see my slides. I am now going to move on to slide 2, if I may. This is a photo of the University of Yangon Department of Law, and I show you this so that I can talk a little bit about the background to the legal system in Myanmar. From 1962, for around 5 decades, Myanmar was in a military regime, and during that time, law was very much undermined. Rule of law was very much undermined, to the extent that becoming a lawyer was not something that most people would ever consider doing. The prestige that we are familiar with being associated with the legal profession was completely destroyed. And in fact, most high school graduates would only study law at a university if they had done very badly in their high school matriculation. So it really had undermined the system. And the level of legal education was very poor as well. So it was a system of rote learning where someone senior would stand up and basically talk at the students rather than having any kind of participatory learning. So I'm going to try now to move to the next slide, if I may. This is a courtroom in Myanmar. It may look very basic to you, but if you can see it, this is actually one of the better courtrooms. So in most courtrooms in Myanmar, you would be lucky to see someone with pen and paper, let alone a typewriter. So the courtrooms have historically, for the last 5 decades anyway, been pretty basic. And indeed, the level of justice that was administered was very, very basic. During the military era, it was relatively common for a military officer to sit in the courtroom, and he would be the person who wrote the judgment, and then the civilian judge would just read out what the military officer had written for him to read. So very, very weak justice system. So then moving on to the next slide, please. And this is a little bit about background to legal aid. As you can see there, 9 out of 10 cases handled in the state court system are criminal prosecutions. And most of those cases will go ahead without the involvement of any lawyers. And that's partly because of the relatively high cost of lawyers, but it's also because the legal profession had been so much undermined that the population at large had very little faith in lawyers. But there is a tradition, Myanmar has a tradition of being very generous, and lawyers would provide free legal advice to, quotes, the deserving. And in fact, the party that is now the governing party, the National League for Democracy, when it was previously a protest movement, had a long tradition of providing free legal advice for political prisoners. And this was a point that I heard made by Daw Aung San Suu Kyi when meeting with an INGO group that was pushing the idea of legal aid. She made the point that there was already some tradition of free legal advice in Myanmar. Going to the next slide, please. So in 2016, a new legal aid law was enacted. And in fact, this was drafted by the Bills Committee of Parliament, which I think right there gives you a sense for some problems in the way things were being done, because it's not typically the role of a parliamentary bills committee to actually be doing drafting. But in this case, the Myanmar Bills Committee did prepare the legal aid law. And as with many laws in Myanmar, it set up a whole network of committees and commissions. So there were lots of regional legal aid boards, but it did very little in terms of specifying what you would need for actual implementation of legal aid. And most importantly, it failed to specify eligibility criteria. So while I think the intention was good, it will take years before that does become a really functioning, useful law. Having said that, it's created an opening to influence the direction of justice and to highlight the importance of access to justice. And it is an opening to lead eventually to legal aid provision nationwide. Going to the next slide, please. So various justice centres have been established in Myanmar in the last 5 to 6 years. These are modelled on South Africa's one-stop shop legal service centres, and they provide free legal representation for the poor who have been accused of a crime and are in the criminal justice system. And they do focus on protecting fair trial rights. And there has been some progress in that space, starting from a very low base. The Attorney General's Office has issued a fair trial manual, and there is now renewed focus on fair trial rights. And the justice centres have established themselves as competent and credible providers of free legal services, and they've challenged the status quo in which arrests were essentially rubber stamped into convictions. So you had a very poor level of criminal justice. These justice centres are starting to improve it. Now, going to the next slide, please. Additional benefits are that they play a role in disrupting long-standing practices like corruption. So during the military era, it would be very common that bribes would be paid to judges and other court officials. And in fact, from my own discussions with members of the judiciary and clerks, I learned that it was almost like a system of scale fees. So judicial clerks would take a certain level of bribe for a certain particular outcome. If you needed a hearing adjourned for 2 weeks, then you'd pay a certain level of bribe. If you needed someone to be acquitted, then it would be a different level of bribe, obviously much higher. But it was almost like a system of scale fees, so really a broken legal system. And the justice centres are helping to address that. They're developing understanding of the role of law in delivering justice. They're providing a safe space for lawyers to collaborate together. Lawyers can support and challenge each other. And the importance of that cannot be overstated. For a legal profession that has been completely undermined and vilified, the opportunity to collaborate with some of your peers is a massive thing. It's a huge improvement. It develops a sense of common cause and empowerment. And I've got in my final bullet point there a thank you to My Justice. My Justice is a European Union funded project with a big presence in Myanmar, and they have supported these justice centres and really taken what was the beginnings of something good and developed it into now something that I think is sustainable and strong. So thank you to My Justice. And I've included their website there for anyone who's interested. So going to the next slide, please. In terms of moving forward, what do I see coming? Well, as I said, the Legal Aid Board is very much in its infancy. The approach to implementing legal aid is going to evolve, and it's going to take a long time to evolve, I think. But the justice centres have shown how you can improve access to justice. They're setting an example of what can be achieved, and that's a massive step forward. Going to the next slide, please. This is a photo of the Yangon Justice Centre, or part of it. You can see it's pretty humble, but it does allow people to come together, to collaborate, to have a sense of common purpose, and that's incredibly important. This photo was taken during a visit by the then chair of the UK Justice Appointments Commission. And it's been great for the justice centres to feel connected with the outside world. and to feel that they have support. Going to the next slide, please. And this is something else that I was heavily involved in setting up. It's a rule of law centre, and this complements and increasingly is working closely with the justice centres. The idea behind the rule of law centres was to take a broken legal profession and to start rebuilding it to scale. I talked earlier about the fact that legal education in Myanmar historically was all about rote learning. There's very little opportunity for participatory learning of the type that we have become very used to. And the rule of law centres look to address that. So they are all about participatory learning, practicing advocacy, having an opportunity to debate with your peers or your seniors, and doing that in a very free and open environment. Whenever I take people to visit the rule of law centres, it's very uplifting because you can sense, you feel as soon as you walk in there, the enjoyment and the pleasure that these people are taking in these learning techniques. So the rule of law centres are providing, hopefully over time, a new generation of lawyers who will have much stronger professional ethics and much stronger practical skills. I'm going to leave it there. I think my final slide just invites any questions later if anyone has any. But thank you very much for listening, and I look forward to hearing from the other panelists. Thank you.
Thank you, Robert. For those of you who have questions for Robert, please save them because we're going to have a Q&A session after all the speakers have spoken. We now move on to our next speaker, Mrs. Adekoya Funke. She is going to speak to us about the legal aid position in African continent. Funke, over to you now.
Thank you very much, everyone. I believe that you can all hear me.
We can hear you.
Can I have my slides up on the screen? Thank you very much. I'm going to speak from the, I'll give you an overview of legal aid on the African continent. And by way of a backdrop, I'd like to start by saying that the African continent has 55 different countries. The countries have different legal systems as a result of the colonization of the African continent. Some countries have an English-based common law legal system. Nigeria is one of them. There are other countries that have legal systems based on the Napoleonic Code as a result of French colonization. There are countries that have a legal system that are a mixture of both. The Dutch legal system, some parts have the English legal system, some parts have the Napoleonic. South Africa is one of those countries that have a legal system that has a combination of their various parts of their colonial history. There are other African countries that have a legal system that perhaps looks European, but has an Islamic foundation. And therefore, we start from the position that there's a motley of systems on the African continent. However, nearly all of those systems of administering justice depend on a legal profession in one way or the other. Can I go to the next slide, please? Thank you. So from there, I'd like to move to the point that even where these legal systems exist, not all African countries have a state-funded legal system. But that does not mean that legal aid does not exist. We find out that in many countries, faith groups, religious organizations, and the legal profession provide some sort of unstructured legal aid to support what is called the indigent, or as we've heard before, the deserving. Now, in the countries where there is a state-funded legal aid system, it doesn't cover all offenses. In some countries, it's criminal law. Nigeria covers both criminal offenses and civil offenses, but they're restricted. coverage of state-funded legal aid is also not countrywide, generally. And this is because most African countries, there's a high rural populace and a not so high urban populace. And to the extent that there's a legal system where lawyers are actively involved, and these are the people who tend to provide legal aid on a pro bono basis, you would tend to find such services available in the urban centers. And so the rural parts of the country are not effectively covered by access to justice in terms of having legal representation. Now, even where budgetary allocation exists by way of a state-funded system, it is generally insufficient. The focus of many African countries has been on developing its infrastructure, developing its health services, developing access to education, and also military defense. And the legal system, and to that extent, state-funded legal aid, has come a poor third or fourth or fifth or sixth, as the case may be. So the budgetary allocation is insufficient. And even where there is state-funded legal aid, it's generally not available at every stage of the criminal justice system, not to talk about the civil justice system. So for instance, at police stations, where the citizen will probably have the first interaction with the justice sector, there is very little access to some sort of legal support, either by way of legal advice or legal representation. Where legal aid is available, it is generally at the point of either incarceration awaiting trial for criminal offenses or when a trial has commenced. So can we go to the next slide, please? Now, what that has resulted in has been a focus some 15 years ago now by African countries on having some sort of a countrywide approach to legal aid. There was a conference that was held in Malawi in 2004, and that resulted in the Lilongwe Declaration on accessing legal aid in the criminal justice system in Africa. And the perception was civil claims are claims between parties and were not as important as providing aid and access to justice in the criminal justice sector, where it was the might of the state against the individual. Noting that in many countries, the access to justice, the rural poor, could be up to 70% of the population. That conference was attended by 21 African countries, and they focused on how could we look at providing access to justice to African citizens by non-lawyers and other service providers, noting that in many African countries, the population in terms of the ratio of lawyers to the rest of the community is not great. And therefore, asking lawyers alone to be the providers of legal aid, either by a state-funded system or by voluntary systems, would not provide sufficient legal aid. So that was the focus. What came out of the conference in Lilongwe? Can we go to the next slide? The Lilongwe Declaration looked at what was supposed to be the objective of legal aid in African countries. And they focused on 3 areas. And I'm quoting from the declaration: reduce reliance upon the police to enforce the law, to reduce congestion in the courts, and to reduce the reliance upon incarceration as a means of resolving conflict based upon alleged criminal activity. Over the last 15 years, the focus really has not been so much on reliance upon reducing reliance on the police to enforce the law. The focus has been on how to reduce congestion in the courts. And that has been done by focusing on ADR mechanisms to resolve matters either before they get into the courts or even while the matter is in court. And reducing reliance upon incarceration and that has been using additional correctional techniques. And the two that have been most discussed and talked about, and I'll come to further discussions of that in a moment, have been community service and plea bargaining. So you find out that in many African countries, there has been a focus on moving to ADR mechanisms by way of mediation centers to resolve disputes. And we have actually discovered that in many African countries, even when there's a complaint made at the police station, you tend to find out that sometimes even the police themselves will say, look, can't you resolve this matter by either having the complainant compensated in some way by the alleged accused? But many countries have actually set up established mediation centers, some run by the government as an appendage to the court system, and many that are privately set up and privately supported, just to reduce the pressure on the court system and thereby reducing the congestion in the court, and as a means of providing some sort of legal advice or legal representation to those who are involved in the court system. In terms of additional correctional techniques, community service has been much discussed, but as of 10 years ago, the United Nations Office on Drugs and Crimes implemented a survey throughout Africa. And community service, whilst was much discussed, had not effectively come into force 10 years ago. As of now, some countries are looking at community service. Nigeria has taken it on board as a country where community service would be an alternative to incarceration. And plea bargaining has also been something that is much discussed and has been implemented in Nigeria as well. And I'll discuss that in further detail in a moment. So those are the objectives of the Kilongwe Declaration. Can we go to the next slide, please? Now, I'll be a bit specific and speak about Nigeria, which is where I'm from. Because as I've said, 55 African countries, so many different legal systems, I'd like to be slightly specific. Legal aid in Nigeria, established statutorily as far back as 1976. We currently have an updated Legal Aid Act in 2011. The Legal Aid Act says it is to provide free legal advice and legal representation to indigent persons in certain cases. So there is some sort of a means test, but it is pretty fluid. The reason being the majority of the populace, especially in the semi-urban areas where the Legal Aid Council works, the rural areas, they tend to be non-existent. But in the semi-urban areas, you still find out that a lot of those who seek access to legal aid are clearly in need and cannot afford the services of lawyers who are in fact not in sufficient supply. Now, legal aid doesn't cover everything. In terms of criminal matters, it's murder, grievous bodily harm, stealing, rape, armed robbery, accessory to those offenses. So what you would probably look at as criminal matters that have the likelihood of a high prison term. In terms of civil matters, the Legal Aid Council is even more selective. They look at claims, civil claims that arise out of employees' compensation. So for instance, if there's an allegation that an employee is entitled to compensation that he or she has not received and cannot fund the litigation by himself or herself, the legal aid would step in. Obviously, where there are issues of fundamental rights which are guaranteed by the Constitution, then the Legal Aid Council would step in. And then other civil claims that arise from criminal activities for those who are qualified. The idea is still to find a speedier dispensation of justice. So the scope still is restricted, and that's the state-funded scheme. Having said that, as I had initially indicated, faith societies, church groups as well also provide prison, especially at the prisons, provide free legal advice and have lists of lawyers that they can refer inmates in prisons, especially those awaiting trial, to enable them have access to justice and be properly represented before the court system. Can we go to the next slide, please? So in light of the Lilongwe Declaration, Nigeria has implemented citizens mediation centers. The centers are state-based and state-funded and are usually set up as an accessory to the Ministry of Justice. So they are funded by the Ministry of Justice. Invariably, they are not located within the confines of the Ministry of Justice. They have a separate building, separate staffing. It tends to be a walk-in center. And so the idea is obviously improving access to justice for the indigent, for the less privileged, for the vulnerable members. Sometimes the citizens mediation centers actually read of incidents in the newspapers and they themselves go out and investigate and advise as to rights. For instance, if there's a mass collision transport incident, or for instance, if a building has burnt down in a particular highly populated area, you could find that Citizens Mediation Center advocates will actually go there to advise the victims of what their rights could be. In essence, they provide free legal advice, legal representation. Still, the purpose is a speedier dispensation of access to justice, whilst trying to ensure that people get out of a court system which is congested and which is overburdened and which is slow. Can we go to the next slide, please? Now, in Lagos State, the state government has actually set up an Office of the Public Defender. Now, the Office of the Public Defender is a state version of the Federal Legal Aid Scheme. The Office of the Public Defender is located within the Ministry of Justice. They have been set up in about 2 or 3 other states in Nigeria. The idea is to provide defense in criminal and civil matters to the indigent and the oppressed residents. There are some issues. Can we go to the next slide? And I will then talk about the issues with access to justice in Nigeria and the legal aid scheme. Now, firstly, most ADR centers, mediation centers, are walk-in. So you go in for a physical meeting. To the extent that technology is used, it is used within the ADR centers to maintain files and to maintain records. Because users are indigent, most of them have no access to digital platforms, they have no access to technology, and therefore holding online mediation meetings is something that has not happened. What we discovered as a result of COVID-19 in Nigeria is that a lot of the ADR centers during the lockdown were not able to provide legal services because they had no online platforms. And even if they did, the clientele didn't have the necessary knowledge to be able to access those platforms. Now, the second side of it is that even to the extent to which the Ministries of Justice has set up a public defender unit to provide defense in criminal matters, there's a distrust of using the Office of the Public Defender because it's based within the Ministry of Justice. So one arm of the Ministry of Justice is seen to be prosecuting, and another arm is seen to be defending. And therefore, there is a sense of this can't work. The public defender can't really defend an accused person when he's sitting across the table or he's sitting next door to the office of the public prosecutor that is defending the same case. And so the office of the public defender, even where it has been established in 2 or 3 states, have not been as well utilized as people would have hoped. Most public defender activities are by private voluntary organizations. The legal profession, the Nigerian Bar Association, encourages its lawyers to get involved in pro bono schemes, and by that provide legal access to the courts by way of providing defense usually in criminal matters. Church groups are also quite active. So where the access to the legal system is concerned for the rural poor, the public defender unit has not been as successful as the government would have hoped. Plea bargaining is something that has been looked at with skepticism. And the reason why it is being discredited within Nigeria is that you hear of plea bargaining mostly in high-profile, high-value cases, corruption cases, for instance, fraud cases, where the public actually expects incarceration. You have to do time for what you have done. And those are the cases where you hear plea bargaining. In the lesser value theft cases where you would expect that plea bargaining could be used, you end up having incarceration. Now, it's not clear whether this is because plea bargaining is not made an option in lesser value cases, or whether it is actively progressed by counsel in these high-profile, high-value matters. But to the general populace in Nigeria, plea bargaining is discredited. It seems as if this is something that only the rich and the high and mighty have access to as a means of avoiding punishment for crimes to which they have admitted. Restitution is something that has also been discussed in the last 2 or 3 years. It has not yet been generally adopted. There's various state legislation that have indicated that for certain crimes, especially financial crimes, forfeiture of assets is part of the system. But restitution in terms of criminal matters has not yet been generally adopted. It's something that's still under discussion. Community service is a recent innovation, and one that the public has embraced and has supported, but has not yet taken off. The issues that arouse community service is, there are basically 2 issues. How do you ensure that those who are sentenced to community service actually carry out the community service as the alternative to incarceration? And secondly, the cost of monitoring community service would probably be an additional cost in terms of having either a police warden or someone there to ensure that the community service activity is being carried out. And this is where technology may become useful. It's being considered. It would also depend, though, on the type of community service and the belief that perhaps if the person who's sentenced to community service can either upload a photograph showing himself or herself performing the community service, or upload details confirming that the community service requirements have been complied in, then this perhaps would be another way in which community service would be acceptable as being a viable alternative to incarceration. So that's where we are now. And I hope that I'll have something to take away from the other panelists and go back and say, well, why we can also look at this as a means of ensuring access to justice to all, and especially to the rural poor in Nigeria. Thank you.
Thank you, Funke. Thank you very much. Very interesting about the situation in the African continent. Now, let us move on to our next speaker, Professor Van den Berg, who will speak to us on the question of whether it's useful for provision of legal aid for the international court or adjudication bodies. Professor, over to you. They can't hear. They cannot hear us. Can you hear us now, Professor?
Lip reading. And if I understand the lip reading correctly, then I have to start my presentation. I hope everybody can hear me well.
Yes, we can hear you now. Professor, over to you. Thank you.
Okay, now I can hear you too. All right. Good afternoon, everyone, and good morning to the others. Thank you very much for the kind introduction. It's indeed an honor and privilege to participate in this panel with my colleagues, so esteemed, and look forward to the discussion. The topic I'm going to address is legal aid in international arbitration. And if you address this topic, the first question, of course, is what is legal aid? And for that purpose, if I may move on to the next slide, please. I take the definition proposed by the International Bar Association, its guidelines for legal aid principles. I see here on the slide is legal advice, assistance or representation for people or groups which cannot afford pay privately for legal help, is mainly provided by lawyers for specific legal problems and is funded in whole or in part by the state, and includes court fees, waivers and other financial concessions. But this is what the IBA tells us, what is defined as legal aid, and I will adopt that here in my presentation. Now, this legal aid, so defined, generally is not available in the field of international arbitration. We just heard presentations, Robert and Funke. There is legal aid available to a certain extent and to be improved, as I understand both speakers. But in international arbitration, there's no legal aid available. And the question is, why is that so? Well, if we move to the next slide, please. If you look on the national level, as I just mentioned, one of the characteristics of legal aid is that it is provided at least by a part by the state, generally in the context of state court proceedings. But arbitral tribunals are generally considered not to fall under the definition of courts in national legislation, especially in Europe. I think about the Dordtse judgment by the International Court of Justice, or the European Court of Justice, which is confirmed also in the Achmea judgment recently. Arbitral tribunals are not considered courts in Europe. And when arbitral tribunals exercise judicial functions, they are contractual in nature, that's the argument, as the parties have voluntarily agreed to submit a dispute to arbitration. And that is, so is the theory. That means that they have renounced the advantages of state proceedings, which includes indeed the possibility of requesting legal aid. Then please, the next slide. If you look on the international level, international arbitration, both commercial and investment, is generally decentralized in nature. And unlike other areas of international law, for example, trade law, I will mention that in a moment, there is no centralized supranational organization capable of adopting and applying universal rules of legal aid. Now, that brings us to a theoretical level and debate, and please the next slide. On the one hand, you have conflicting considerations. On the one hand is party autonomy. Now, particular autonomy concerns the choice to submit a dispute to arbitration. And such a choice necessarily entails many things, including renouncing state court proceedings, and therefore all its benefits, one of which is indeed legal aid. So that's the one hand. On the other hand, you have the ensuring a level playing field for all participants, in recognition of the fact that bargaining powers are not always equal. This applies in particular to smaller companies and developing countries. Now you can see here the debate between the opponents of legal aid in arbitration, which rely on party autonomy, while proponents of legal aid will focus on equal opportunity of access to justice. Now, let's see what is available at present. Next slide, please. The existing frameworks, first of all, what you can look to add is the Financial Assistance Fund of the Permanent Court of Arbitration. It aims at helping developing countries meet part of the cost involved in international arbitration or other means of dispute settlement offered by the PCA. And the types of costs that they are reimbursed include the fees and expenses of members of the tribunal, the expenses of implementing an award or other decisions of recommendation of such a body, and payments to agents, counsel, experts, and witnesses, and operational and administrative expenses. So that is the PCA. My understanding is it is used from time to time, but not often. A similar mechanism exists at the ICJ, the National Court of Justice, in the form of the Secretary General's Trust Fund to assist states in settlement of disputes through ICJ. A third one I may mention is the Court of Arbitration for Sport, the CAS, which deals with, at least in part, disputes involving individuals. And legal aid there is also available to natural persons whose income and assets are not sufficient to allow them to cover costs of proceedings. We go to the next slide. Now, if none of these frameworks are applicable or available, parties resort these days to third-party funding in international arbitration. And that means that the legal fees and expenses are paid for by persons or entities that are unconnected with or not party to the proceedings. That enables the parties to pursue claims or counterclaims that might otherwise not have been requested funds to do so. But then in exchange for these funding, third-party funders often require that part of the award of damages be shared with them to compensate for the risk of that funding. There are two problems with this, with third-party funding, at least perceived problems. The first one is that there's a lack of transparency, and that is why you see that in a number of jurisdictions and arbitral institutions now require the identity of the third-party funder to be disclosed. And the other problem, that is to investment arbitration, the other problem is that it is available to a claimant investor only, but rarely available to a respondent state. At least third-party funders are not prepared to fund a state respondent because they're always respondent and not a claimant. So very often, very rarely they are counterclaimant. Next slide, please. Another interesting framework for legal aid, that is the Advisory Center of the WTO, Law in Geneva. That was established in 2001 for the benefit of developing and least developed countries that are members of the WTO. There's three primary functions, as you see on the slide. It provides legal advice on the WTO law. It provides support during the WTO settlement proceedings, and it provides training to government officials. Here the legal advice and training are provided free of charge to least developing countries, but the center does charge modest fees to support in dispute settlement proceedings. And the WTO Law Center also provides the capacity building for those who want to be involved in those proceedings. Next slide, please. Now, if we leave the existing frameworks aside, briefly I would like to mention the UNCITRAL proposals for Work Group 3 for initiatives for legal aid. So what they propose is an establishment of advisory centers similar to the advisory center of the WTO law. They want to create funds to support parties similar to the Secretary General's Trust Fund that exists before the ICJ. They would like to use third-party funding for claimant investors, which I mentioned already happens frequently. And then they would like to explore the use of third-party funding for respondent states, which, as I mentioned, is relatively rare. Next slide, please. I would like to offer a few comments and thoughts. First of all, UNCITRAL rightly recognizes that given the nature of international arbitration, the provision of legal aid in this field will have to be decentralized. As unlike the case of WTO, where there will not be one body or fund to cover all proceedings, since different rules and different laws apply in different cases. That also means that different institutions will likely come up with possibly different initiatives. Now, in my view, that is not a bad thing. What is important is that legal aid in whatever form is being provided and is available. That said, a relatively institutionalized body like ICSID might be well placed to follow the WTO model and set up an advisory center which goes beyond the provision of financial assistance and includes capacity building. This might be particularly helpful to counter criticisms of investment treaty arbitration as biased against developing countries. For smaller institutions, a legal fund may be more feasible. UNCITRAL's proposals are limited to investment arbitration. I would like to go there further and suggest extending legal aid to the realm of commercial arbitration as well. Many of existing frameworks that I have discussed are rightly focused on developing countries. But small and medium-sized enterprises in commercial arbitration may need just as much support. If international arbitration is to remain a viable means of dispute resolution that represents genuine alternatives to state court proceedings, legal aid must be available to both companies and states. A model that may be practicable in this regard is the legal aid available before the Court of Arbitration for Sport, which takes the following forms. A recipient of legal aid may be released from having to pay the cost of the procedure or to pay an advance of cost. The recipient may choose a pro bono counsel from the list established by the court, or the recipient may be granted a lump sum to cover his or her own travel and accommodation costs and those of his or her witnesses, experts, and interpreters in connection with any hearing. Well, ladies and gentlemen, these are some thoughts I would like to put to you and look forward to the discussion. Thank you.
Thank you, Professor. Last but not least, we will have our next speaker, Mr. Hans van Loon. He is going to talk about the Hague Access to Justice Convention and how the convention may be further promoted to ensure access to justice for all. Mr. van Loon, the floor is yours.
Wall of silence, with a great zoom of silence this time. It seems lip reading for Hans, for you.
Can you hear us?
Yeah, I presume there's something, but...
You may start now, Mr. van Loon.
Can I have my slides, please?
Right, okay.
Presume that is. Can you see the slides? Can you hear me?
We can see your slide. We can hear you. Yes.
Okay. Well, good afternoon. Thank you, Chair. And perhaps we should go on with the next slide already. Can I have the next slide? Yeah. Good afternoon. Promote the rule of law and ensure equal access to justice for all is one of the goals, Goal 16.3, of the 2030 United Nations Agenda on Sustainable Development, as the Secretary has reminded us. Now, access to justice is also a fundamental right guaranteed by the International Covenant on Civil and Political Rights, which applies in Hong Kong, applies in most jurisdictions, and which has been signed but not yet ratified by China. So with the rule of law, access to justice is both a target and a founding principle of Agenda 2030. Legal aid services are not specifically mentioned by the 2030 agenda. Yet, obviously, as we all know, without legal aid, many people involved in issues at the heart of their lives, relating to family, to neighbors, to work, to criminal proceedings, will lack access to the justice system. Issues of access to justice and legal aid are compounded in cross-border situations where more than one jurisdiction is involved. And such cross-border issues are often more complex, and they are becoming increasingly common as a result, obviously, of globalization. Now, in my contribution, given my background with the Hague Conference on Private International Law, I will focus on the role of access to justice and legal aid in cross-border disputes between private actors. But first, let's take a step back. What is access to justice? Now, Mauro Capelletti, well known from his pioneering worldwide project on access to justice in the 1970s, explains that access to justice is more than access to a judge and the organization of courts. Sure, primarily the justice system must be equally accessible to all, without distinction of any kind. But in addition, states and governments must ensure that a justice system leads to results that are individually and socially just and fair. Going to the next slide, please. So, yes, legal aid is essential, but it's not enough. Even where legal aid is available, the justice system must avoid arbitrary and discriminatory results. And that, of course, of utmost importance in vertical situations, in criminal and administrative matters where private people and entities face the might of the state, as Funke mentioned. And it starts at the legislative level with statutes that define the powers of the state over private people. If people can be persecuted or punished for acts that are broadly or ambiguously defined, relating, for instance, to infringement of sovereignty or security, or even more serious, for incitement to such broadly and ambiguously defined acts, then there is no predictability anymore, as emphasized yesterday by Chief Justice Ma. Everyone has to watch out, and access to justice is no longer guaranteed, no matter how generous the legal system may be. So precise statutory definitions are crucial. Now, in access to justice in horizontal situations, in disputes between private actors, persons, small companies, large companies, that also implies independence, of course, requires independence and impartiality of the justice system and equal and fair treatment of the parties. So legal aid is crucial, but it is an aspect of the more encompassing fundamental right and principle of access to justice. Now, as I said, I will focus on access to justice and legal aid in cross-border civil disputes and not deal with cross-border criminal and administrative matters, although in those fields the need for legal aid is obviously at least as important. Due to the limited time, I've selected three types of civil cross-border issues. The first is how to ensure equal treatment to foreigners, where access to justice and legal aid are available to nationals. The second issue is where, in order to resolve a legal issue, the assistance of another jurisdiction is indispensable, how to organize such assistance and provide it free of costs for the applicant. And the third type of issue arises where access to justice and legal aid are not available in the home country of claimants who have a dispute with a foreign party, typically a foreign corporation. In such a case, the question is, can they have access to the court system of the foreign corporation's home country and benefit from the legal aid system in that other country? Going to the next slide, please. So, first issue, access to justice and legal aid are available to nationals, but not on the same footing to foreigners. Think, for instance, of a family dispute, a divorce with one family member in one country and another family member in another jurisdiction, or an employment dispute between an employee and an employer in different jurisdictions. How to ensure equal access to justice of the foreign party to the justice system? Well, the solution is given by the 1980 Hague Convention on International Access to Justice. This multilateral treaty provides that foreigners, and that means both nationals and residents of states parties, are entitled to legal aid for court proceedings in each state party without discrimination. That also applies to legal advice, provided the foreigner is living in the state party where he seeks such advice. Also, the convention removes obstacles to foreigners such as security for costs of proceedings, which normally they should pay before they may even start proceedings in the jurisdiction. And as a counterpart, the convention guarantees that if the foreigner loses the proceedings, then any order for payment of costs of the proceedings is made enforceable free of costs in his country or any other state party. And the convention also facilitates the transmission of legal aid requests to the state where the court sits, free of charge. Now, the Hague Access to Justice Convention is one of a triplet. Her sisters are the Hague Service Convention and the Hague Convention on the Taking of Evidence Abroad. The Service and Evidence Conventions are in force for China, and also for Hong Kong, and a number of countries in the region and beyond. But the Access to Justice Convention somehow is lagging behind. It's not being ratified by China, and in the whole region, only by Kazakhstan. I think a lack of understanding may explain this poor record. People may think that the convention obliges states to offer more legal aid to foreigners than to nationals. But that's not the case. It merely offers the same legal aid to foreigners as to nationals living in the forum. Moreover, even if your own legal system does not discriminate between nationals and foreigners, you might ask, what is the use of the convention? Well, other states still do. And your citizens will benefit from the convention in those other states' parties that do not automatically guarantee equal access to justice. So all in all, I would say that this convention is a vital element of the global legal infrastructure, and it deserves, it deserves to be more widely ratified. Going to the next slide, please. The second issue where a request is made by one jurisdiction to another jurisdiction for help to a private applicant. How to provide such assistance and how to provide it free of costs for the applicant. This issue arises, for example, in the context of proceedings on international child abduction, where a parent has taken a child without permission to another country. The 1980 Hague Child Abduction Convention sets up machinery through a central administrative authority and courts to return such wrongfully removed children. That convention has been ratified by more than 100 jurisdictions. Hong Kong and Macau are parties, but mainland China has not yet joined this instrument. The convention provides for free legal aid, but also allows a reservation, which Hong Kong has made, that restricts legal aid to what is already covered by Hong Kong's legal aid system. So foreigners will at least have equal access to legal aid as Hong Kong citizens. And likewise, the 2007 Hague Child Support Convention provides for cooperation via central authorities and courts to help, to put it simply, mother and child to recover maintenance from father in another state party. That convention not yet in force for Hong Kong or for China, but it is also a vitally important instrument because internationally split families are everyday business. Moreover, the treaty reduces reliance of maintenance creditors on the public purse, because if mother and child cannot have maintenance from the father in the other country, they will go to the government and ask for support. So that's another advantage of this convention. Like the Child Abduction Convention, this treaty provides for legal aid. The requested state must give free legal assistance for all applications by a child creditor, and it may subject that aid to a test of the child's own means, which usually are, of course, quite limited. We're going to the next slide, please. Briefly on the third issue, which I can best illustrate by last year's judgment of the UK Supreme Court in the Vedanta case. In that case, claimants from Zambia, victims of damage caused by the exploitation of copper mines in Zambia by a subsidiary of the UK Vedanta company, sued both the parent Vedanta and the Zambian subsidiary in the English courts. They did so because they had found that access to justice and legal aid in Zambia were insufficient. And the UK Supreme Court agreed with the lower courts that this was the case, and that therefore the British courts had jurisdiction regarding both the parent and the Zambian subsidiary. Now this example, and there are many more examples, this example shows that lack of access to justice and legal aid in developing host countries of investments by foreign companies may be a factor driving victims of damage caused by a local subsidiary to sue this subsidiary together with the parent they hold responsible in the parent's home country. And with the expansion of the notion of private sector human rights responsibility, refer to the Ruggie principles of the United Nations, such cases may present themselves in future in many more investor countries, including Hong Kong and indeed China as a whole. Going to the next slide, please. In conclusion, in our emerging world society, where cross-border civil and commercial disputes are growing exponentially in number and complexity, access to justice and legal aid, not just within, but across jurisdictions, are of growing importance. The legal infrastructure to provide such access to justice is available, thanks, including, in particular, to the Hague Conventions on Private International Law. There's the General Access to Justice Convention and specific conventions such as the Child Abduction and Child Support Convention. And I would have thought that Agenda 2030 offers an excellent opportunity for states to join these conventions, where they have not yet done so, as part of their pledge to leave no one behind. And then also, finally, states should provide access to their courts in cases concerning transnational civil responsibility of corporations based in their jurisdiction, again, to leave no one behind. Thank you very much.
Thank you, Mr. Hans. We now have around 15 minutes for discussion and Q&A. We already have a few questions that have been sent in, which I will now read. There's a question for Robert in your presentation about the legal aid in Myanmar. There's a question about how in Myanmar, how can a person who is criminally accused and with no financial means get access to free legal representation there? And at what stage would they be informed under the Criminal Procedure Code? And are there any restrictions to such services? Robert.
So thank you for the question. The system, as I outlined, is far from well developed. And so what you would need to do is go to one of the justice centres and seek to persuade the justice centre that you meet their eligibility criteria. At the moment, they have only limited capacity, so they're not in a position to take on every case required. What it highlights, I think, is the need for a more developed legal aid system, such as that in Hong Kong. And it also highlights the need for serious government funding of legal aid. The justice centres in Myanmar are funded essentially by the lawyers themselves and by international donors. And I mentioned earlier the My Justice organisation, which is European Union funded. And so what we need in Myanmar is proper government funding of legal aid. But I sadly am not optimistic that that will be forthcoming in the immediate future, given that the country is suffering economically, as many other places are, from the COVID-19 crisis. So I hope that goes some way to addressing the question. Thank you.
Thank you, Robert. There's a question for Funky. You mentioned in your presentation about the ADR mechanism, particularly the mediation centers there in Nigeria. As a matter of interest, would people need to pay for the mediator in those mediation centers?
In the citizens' mediation centers, there is no payment. to the mediator
they are
because
free.
it is government funded and state supported. In some of the voluntary mediation centers as well, there is no payment. There is, however, a multi-door courthouse structure, which has a mediation center attached to the courts, where when matters go into court, the courts may themselves decide that we think that this is a matter that could be resolved through mediation. And they are then transferred to the mediation center attached to the court. If it is not resolved in that mediation center, it will then go back onto the litigation list within the court. Those mediation centers that are part of the high court system, as in a multi-door courthouse, you would have to pay the mediator, but the fees are minimal.
Right, and most of them are paid by the government. Is that the position, basically?
I'm sorry?
The mediators that you said that the parties do not need to pay.
The citizens mediation centers, which are established as part of the state-funded legal aid scheme, are free. You don't pay the mediators.
Okay, thank you, Funky. Professor Albert, about the possibility of having legal aid in arbitration proceedings that you've just mentioned, do you see there any mechanism that one can think of to prevent the abuse of legal aid in an arbitration setting?
Thomas, if I understood your question correctly, you're referring to the possibility of abuse or use?
Abuse. Abuse of...
Abuse.
Abuse.
I have not seen instances reported one way or the other of abuse of legal aid. What I remember when I was a Secretary General of the Netherlands Arbitration Institute, we had also a fund for those who could not pay their arbitrators. What I did then each time when a party claimed that it had no financial support to pay the arbitrator, I always asked, well, you are a company, could you show whether you have fully paid up your shares? And that was usually the end of the discussion. Apart from that, we use it from time to time. There were indeed parties that were generally lacking funds, financial means for paying the arbitrators, and there we provided the funds, so we could control the possibility of abuse in that respect.
Thank you, Professor. There is a question coming in for Mr. Van Loon about the Access to Justice Convention. Is there any assistance or advice available to help countries which would like to consider joining the convention?
I'm sorry, I can't hear you.
Right, okay. Can you hear me now? Can you hear me?
With difficulty.
Right, now?
Could you repeat the question slowly, please? Because I have great difficulties following you.
Can you hear me now?
Yes.
Right, okay. The question is this. Is there any assistance or advice available to help countries which would like to consider joining the Access to Justice Convention?
Yeah, that's an excellent question. I wish there were. No, I mean, perhaps what could be considered is a slightly wider view of an inclusion of cross-border situations in considering human rights issues generally. So that where there are funds, for instance, to upgrade legal aid in countries, they would include the cross-border aspect, so that there would be an element taking into account the fact that legal aid is increasingly necessary in cross-border situations. The traditional view of human rights is like this. You look at a jurisdiction and you expect that human rights are respected within that jurisdiction. But the idea that we have to do with interaction between all these jurisdictions is still relatively new, and more attention should be paid to that. And then probably one could also think of finding funding for these cross-border issues. And but for the moment, no.
Right. Thank you. Well, we just hope that things can improve in the future. We still have some time for another question. Let me see. We have another question for Robert about Myanmar. There is no assessment criteria under the legal aid law in Myanmar. So what is the biggest challenge in setting criteria and how to overcome that? Do you have any input on that, Robert?
Well, I have some limited input. I mean, obviously, this is the big shortcoming with the legal aid law there. It focuses on setting up legal aid boards and specifying the composition of the legal aid boards, who's going to be on a legal aid board, both at the central level and at the regional level. And it doesn't specify criteria for eligibility. And the reality at the moment is that legal aid system is not properly functioning, and that is why we have seen the justice centres become so much more important and influential. They are functioning outside the government legal aid system, and they do rely, as I said, on both private lawyers being willing to do the work either free of charge or for very low fees, and they also rely on external funding from the European Union and others. And the criteria they set at the moment are not developed. They're not as developed as they should be. I mean, the system is really in its infancy, and I can't overstate that enough. It's just beginning, but it's a huge improvement from what we had in the past in Myanmar, where there simply was very, very limited assistance for people who could not afford to pay. At least now there is some established centre you can go to, and they will have criteria, but it's not easy. I mean, I can't give you deep insights into the precise criteria used at the centres. Obviously, they're overstretched. They take on the cases they can, and they have had some very big successes, but also they have to turn away a lot of cases, sadly. So what we do need is to move gradually over time to a proper government-funded legal aid system, but we're not there yet.
Right.
Thank you.
Thank you, Robert. I think we are almost there. I just want to say thank you again to the panel of speakers. A very, very good show and very eye-opening. And also thank you for joining us in this session, but do stay with us. I think that we will have another session later on.
Thank you. Thank you, Dr. So, Mr. Pear, Mrs. Edikoya, Professor Vanderberg, Mr. Van Noon, the speakers of the first panel, for the insightful discussions on enhancing legal aid services to ensure access to justice for all. We will now have a short 5 minutes break and resume at 4:45 p.m. for the second panel session. Thank you and see you soon. Welcome back. For our second panel session on keeping up with the times, capacity building for judicial officers, we are pleased to have invited Ms. Winnie Tam, SC SBS JP Barrister, International Arbitrator, Mediator of the Vu Chambers with us today. Ms. Tam is one of the most prominent barristers in Hong Kong, specializing in intellectual property and general civil disputes matter. She has served as the chairman of the Hong Kong Bar Association between 2015 to 2017. Ms. Tam, may I now pass the floor to you, please?
Good afternoon, ladies and gentlemen. I have the great honor to be here to moderate this session with very distinguished speakers amongst us. And I am physically joined by Ms. Justice Hartman, former non-permanent judge of the Court of Final Appeal of Hong Kong. And very soon, two more speakers will be waiting to join us. And they are Judge She Hanqin, Chinese judge of the International Court of Justice in The Hague, and yet another speaker from Holland, and that would be Professor Nicole Shriver. They're all online now. Now, the topic of today is essentially about rule of law. Now, everyone knows that a strong and independent judiciary is one of the cornerstones of rule of law. Yet, the judiciary is not immune at all from challenges arising from the environment, the health and safety issues, and political issues. Today, we will have the opportunity to have speakers exploring two particular aspects of judicial independence from the point of view of capacity building in the judiciary in this day and age. We all know that we face extraordinary challenges in terms of health and safety, and extraordinary challenges on the political front. And today we have two judges and former judge who have great experience in dealing with these matters, and also Professor Shriver, who is a prominent international lawyer in public international law from Holland. And without further ado, I shall introduce our first speaker, Judge She Hanqin. Judge She is the pride of Chinese legal women, I would say. She is currently the Vice President of the International Court of Justice. Judge She holds master and doctoral degrees from Columbia University School of Law. She had worked in the Law and Treaty Department of the Foreign Ministry of China between 1980 to 2003 as the Director General. She was then elected to the International Law Commission in 2002 and worked as a member there until 2010. Now, Judge She was the first, one of the first female members and first chairwoman of the commission. And she was posted in 2003 to the Kingdom of the Netherlands as the Chinese ambassador and the permanent representative to the Organization on the Prohibition of Chemical Weapons. Judge She was also the first Chinese ambassador to ASEAN and legal counsel of the Foreign Ministry. She is widely published on public international law, both in Chinese and English. In 2018, she was elected to the International Court of Justice and as the Vice President of the court, where she had been a judge of the International Court of Justice since 2010. Now, without further ado, I would like to hand over the mic to Judge She. Thank you.
Thank you, Madam Tam, for your very kind words addressed to me. It's indeed a great honor to be here today. As you instructed, I will talk about capacity building in an emergency case, to take the example of COVID-19 pandemic reaction done by the court. As you know, when the COVID-19 pandemic spread in Europe early this year, The court reacted immediately, giving the priority to the safety and health of the judges and the staff of the registry. The court adopted its working methods to the need to work remotely. First of all, the registry has to prepare all the necessary technical devices, equipment, and make sure that each judge, wherever she or he may be located, has access to the video conference facilities for the conduct of judicial meetings. In practice, when judges are located in different parts of the world, technical support often proves difficult and challenging. Judges not only have to possess the right equipment and devices, but they also have to know how to use them, particularly how to handle technical problems they may encounter during the course of virtual meetings, and have the problems resolved with the remote assistance of the court IT systems. Happily, although we, the judges, as you know, no longer young and do not belong to the digital generation, the judges so far have managed to use their devices quite well. Administratively, the court quickly adopted internal practice directions for the conduct of virtual meetings. Because constraint measures and international travel ban were imposed in many countries, the court's public hearing scheduled in the first half of the year had to be postponed or rearranged. In late April, the court held its first plenary virtual meeting in its history. The president and the registry were present in the deliberation room of the Peace Palace, the seat of the court, while the remaining members of the court participated in a meeting remotely via video conference. As the court indicated on its website, it wishes to assure the member states of the international community that in spite of the current circumstances, it will continue to discharge its judicial functions and to deal with the matters newly submitted to it or already pending before it. As the judges well adapted to the new working method, the court gradually picked up its work pace and extended the new method to the judicial work. You know, some states raised the issue with the court, questioning whether it's in conformity with the statute and the rules of a court to hold virtual hearings, and what the legal effect of the judgment that is delivered through video link, since there's no provision on the matter in either the statute or the rules of the court. After careful considerations, the plenary took the view that in the future, in an emergency situation as the one we are facing, the court may have to adapt to the remote working methods. So on the 25th of June 2020, as part of the ongoing review of its procedures and the working methods, with the recommendations from the Rules Committee, the court decided to amend Articles 59 and 94 of its rules. The amendment to Article 59 makes clear that the court may decide for health, security, or other compelling reasons to hold a public hearing entirely or in part by video link. This amendment is contained in a new paragraph 2 of Article 59. The previous Article 59 has been renumbered as Article 59, paragraph 1. The amendment to Article 94 is in existing paragraph 2 and provides that the reading of the court's judgment in a case may also take place by video link when this is necessary for health, security, or other compelling reasons. The amended rules took immediate effect on the day of their adoption. Under the amended rules, on the 30th June 2020, the court held public hearings on the question of the court's jurisdiction in the case between Guyana and Venezuela at the Peace Palace in The Hague, the seat of the court. In view of the current COVID-19 pandemic, for the first time, the hearing took place in the Great Hall of Justice using video conference technology and with the physical presence of some members of the court and some members attending remotely by video link. The representatives of the parties to the case addressed the court by video link. Members of the diplomatic corps, the media, and the public followed the hearings through a live webcast on the court's website, as well as on UN Web TV. One aspect relating to this hybrid method of the court's hearing is that each time the court will make a point of having at least 8 to 9 judges present in the Great Hall of Justice, so as to maintain the solemnity and authority of the judicial function of the court. Of course, with the social distancing and safety measures in place. By the way, I should tell the audience, there are 15 members of the court, and usually we hear the case by the full court, and oftentimes we have 1 or 2 ad hoc judges in each case. With a few months of practical experiences of this hybrid method, it is quite obvious to us that the effectiveness of the remote working method very much depends on the quality and availability of modern technology. Take the court example. At the seat of the court, we have the full technical support of the IT service. With the judges at their home countries, they must also have such technology and service available. To provide technical assistance remotely from the court side sometimes could be inadequate. So this is the first challenge for us. Coupled with the technical availability is the question of confidentiality and security, both of the court's documentation and court's deliberation and hearing. It took the court's IT quite effort to work on this issue. According to the rules and the practice, before the public hearing, all the documents and written pleadings of a case should be kept confidential. This is also required of court's deliberations. How can we absolutely guarantee the safety and the security of the judicial activities and the documentation? And to what extent the court could afford to work online certainly present a big challenge to us. So this is the second challenge. Third one, due to technical constraints, video conferencing has its limitations. First, we have to cope with the different time zones of the judges, the delegations of the parties, and other relevant parties. So sometimes the working hours have to be shortened, or working days have to be prolonged. When a technical problem occurs, for instance, all of a sudden there's no image anymore, or there's no sound of the speaker, the hearing or the meetings have to pause till the problem is fixed. Sometimes it could take quite a long time, and this is especially serious when a court hearing is going on. More importantly, we have to recognize that video conference is not as effective as direct interaction, and direct interaction could really bring in more message between the parties. Remote meetings may not result in thorough exchange of views. So this is another defect. Lastly, we have to ask ourselves whether this will become really a new normal in the future for the court. In a post-COVID-19 era, video conferencing will likely become much more popular and more used. regardless of existence of emergency or any concern of security. To what extent and what circumstances that the court should adapt to this method for judicial activity certainly needs to be further studied and put under constant scrutiny. Last, I'd like to say a few words about the Judicial Fellow Program. Each year, the court will select 15 to 16 young scholars from different universities around the world to join a fellowship program at the court. These young scholars each will work with the judge for 10 months in the court, from September till July of the following year. Despite the difficulties caused by the pandemic this time, the court decided to go ahead with the program. At the moment, 16 fellows are now in The Hague, working remotely with their judges. So we consider this is a contribution by the court to the international community for the dissemination and the teaching of international law. And despite the difficult situation caused by COVID-19, we are very happy we can continue to contribute in this aspect. Madam Tan, I think I have used up my time. Should I go on to another topic as the relation between politics and law, or should I stop here, let other speakers to carry on this topic? Maybe I can join the discussion later on
Just sure.
this issue.
In fact,
Thank you for your attention.
Thank you very much. It was very interesting to hear your sharing on the situation, how the ICJ was handling the COVID situation with the hybrid hearings and the changes of rules and practice in order to cater for the situation. I should have mentioned, and I forgot, I do apologize, that to say that our fourth speaker, Mr. Makdum Ali Khan, has been unable to join us today due to being indisposed. So, Madam Judge Xu, you in fact have more time. So we would like you very much to share your experience and your views on the law and politics issues. Please go ahead.
Thank you, Madam Tan, for your guidance. Now I shift to another entirely aspect of the capacity building theme. That's I would consider is not a new challenge under the current circumstances. I would consider this is a perpetual issue, relationship between law and the politics. And of course, for judicial officers, this also remains important aspect that we have to bear in mind. This is something we have to build our capacity and build up our strength to be able to handle cases that involve politics. For the court, I must say, this is not something new and not something novel with our judicial activities, because people have to understand that, first of all, the court, ICJ, only deals with cases, disputes between states. And when they decide to come to the court, I have to say the decision itself is a political decision. And the decision to come to the court itself, per se, is just as important as the outcome of the case. Secondly, I have to stress that subject matters of the dispute that are brought to the court often concern territorial disputes, use of force, maritime boundary disputes, terrorist bombing, racial discrimination, serious violations of human rights. In a nutshell, such allegations inherently involve politics. and you can see many of the disputes also concern fundamental interests of states. So this is the second aspect. The third aspect is the situation we often face, that dispute oftentimes arises from a long hostile relationship between states. I gave the example in the hostage crisis cases between Iran, United States and Iran, when the U.S. embassy and consular offices were seized by Iranian students. U.S. brought the case to the court against Iran on claims that Iran seriously violated its international obligations under the Vienna Convention on Diplomatic Relations and Consular Relations. Iran claimed, this is not a single isolated incident, but it's a 25 years of serious exploitation by the U.S. Of Iran, and this is much more complicated than the single incident. Then the court stated that the question for the court to see is whether the applicant party, asked court to decide, adjudicate on the point of law or fact. And Iran did not say, on what point of law or fact it wished the court to adjudicate, or that the court should not adjudicate. And what Iran described is mainly a broader political context from which the dispute arose. So the court rejected Iran's claim, but this case also shows that the relationship between politics and the law is not as simple as people would think. So you can see from the nature of the dispute, the subject matter of dispute, and the context of dispute for the court, this is a very normal situation. We can't separate the two. But for the court, we have to decide only the legal aspect of the issue brought before the court. For the court, I have to stress, in international law, there's no such doctrine as a political question doctrine, as in some national constitutional system. And what we have to decide, the court has to decide, is to see whether the party has raised a point of law or fact that is in dispute. And this is what court has to do. And for the court itself, as the principal judicial organ of the United Nations, it's obliged to fulfill the purposes and the principles of the Charter by discharging its functions to settle disputes between states in its own way to contribute to peace and security. In our judicial practice, oftentimes the court would receive requests from the General Assembly to address certain legal questions. In answering these questions, actually you can see some of the issues actually with political background and also with political ramifications. For instance, the court gave a few advisory opinions relating to decolonization issues. And I can name a few important advisory opinions given by the court in recent decades. For instance, in the war case, the legal consequences, the court asked the court to address the legal consequences of the construction of a wall in the occupied Palestinian territory, and another question on the legality of the use or threat of nuclear weapons. And recently we gave opinion on legal consequences of the separation of the Chagos Archipelago from Mauritius in 1965. From the topic, each of them, you can tell that there is a political element involved, and the question is not purely technical. For the court, even a case has deep political implications, it doesn't mean the court is addressing a political issue. We are only addressing the legal aspect of the issue. This is what I want to say, and certainly I would welcome any questions that will help us to have a better exchange.
Thank you very much, Madam Justice.
I think, Madam Tan, I should stop here, and because I just feel that I need to see how the audience react, and then we can have a meaningful dialogue. I should not go on like this. Thank you for your attention.
Thank you very much, Judge Shi. It's a hugely interesting presentation for the hugely interesting work you're involved in the International Court of Justice. I'm sure that there will be questions to follow, but because there are 3 speakers instead of 4, so I think we will reserve the question and answer session to the last. So members of the audience, if you have questions, you can save them and try to transmit them on the internet in due course. Now next, we have the Honorable Mr. Justice Hartman, from former non-permanent judge of the Court of Final Appeal, Hong Kong. Ms. Justice Hartman was first in the Court of First Instance, and I remember that Ms. Justice Hartman was very often in charge of the public law list, so he was involved in deciding a lot of extremely difficult cases in terms of this political content. Ms. Justice Hartman was actually born in India and graduated with a law degree from University of London, obtained at the University College of Rhodesia, which was at the time an external college of the College of London. And then he was admitted as an attorney, and he was a Rotary Public in Zimbabwe before he joined the Hong Kong Legal Department in 1983. Which is, it was then called the Attorney General's Chambers. He was appointed a senior Crown Counsel in 1984 and Deputy Principal Crown Counsel in 1989. And then he joined the District Court as a member of the judiciary in the 1991, and then rose through the ranks to the Court of Appeal in 2008. And then he served as a Justice of Appeal between 2008 and 2012. Now, Ms. Justice Hartman was formerly a non-permanent judge of the Court of Final Appeal, and throughout the years he had heard a lot of politically sensitive cases, and we kept reading very erudite judgments from Ms. Justice Hartman on cases of great public interest. Now, without further ado, I will hand the mic over to Ms. Justice Hartman for him to share with us his experience in tackling these highly politically sensitive cases during his time as a judge. Thank you.
I'd like to start, if I may, with a little short history. First, looking at the nature of Hong Kong judges. Hong Kong judges are bred essentially in the tradition of the English common law. At one time, so legend would have it, judges liked to remain very much aloof. I think they took a certain pride in the fact that they knew very little about the day-to-day happenings in society. There's a well-trodden saying that one judge had to ask who the Beatles were. Today, however, certainly in the time that I was in the judiciary, judges have become more informed. They read newspapers, they watch television, they've grown especially to understand the reach of social media. And indeed, many of them, and I don't include myself here, are members of Facebook and other social media platforms. Judges today, therefore, are well aware of political dynamics and, like everybody else, are open to the influence of the media. As to the time when I was actively involved in what some may call politically sensitive cases, I think I need again just to give a little history. In 1997, Hong Kong was returned to the sovereignty of the People's Republic of China. The transfer took place under the concept of one country, two systems. That concept was contained in a document of constitution, our basic law. And that basic law contained a justiciable Bill of Rights, which provided that any domestic law which offended it would be of no force and effect. In the years that followed, litigants increasingly looked to the provisions of the basic law for what they believed to be declarations of their political rights and protection of what they saw as their fundamental human rights. And during that time, over a span of some 10 years, I was the judge in charge of what was called the Constitutional Law and Administrative Law List, at least at first instance. And I was therefore the judge who had to give a great many judgments at first instance. A number of matters in that decade came before me which were undoubtedly both politically sensitive and at exactly the same time of great media interest. Perhaps by way of example, and I give it by example only, one case comes to mind. That was when a number of political activists in Hong Kong sought a declaration that they had been secretly watched by the policing authorities and that secret surveillance was unlawful. It was unlawful because it was not authorized by law as required by the basic law, our Constitution. If I found that secret surveillance by the policing authorities was unlawful, as indeed I did, we were then left with the question, what happens now? What happens if the police stop all forms of private secret surveillance, but there are nevertheless criminals plotting crimes, terrorists perhaps plotting terrorism? That required some form of stopgap measure until the Legislative Assembly was able to actually institute some laws to make secret surveillance lawful. What I need to emphasize, without going into the details of it all, is that the stopgap measures were legal measures. They were not political measures. What was required, therefore, was a search among precedents and looking at other jurisdictions, in this case it was Canada, to come up with a similar situation where a law had been set aside as being unconstitutional, and that then left a lacuna, a gap, that needed legally to be covered temporarily until the legislature could put something in its place. I put together what I saw as a legal measure. It was approved, although the Court of Final Appeal didn't like it in certain respects and polished it and made it better. But the issues throughout were legal issues and not in any way political issues, although, of course, it was clear to everybody that the case had political ramifications that were very profound. I think the situation then is that in these type of cases, especially human rights cases, although many of the principles set down in the Constitution, our basic law, gave me a broad discretion and gave other judges a broad discretion, I did not see that they gave me permission in any way whatsoever to become my own lawmaker. Judges have to learn the art of separating their personal preferences, their personal ideologies from the dictates of law. For myself, we all create our own little ways of ensuring self-discipline. What I would do whenever I saw in the newspaper that there was something brewing, if I can put it that way, that I knew stood a very good chance of coming before me, I would simply not read it. I would ignore it. If there was an article in the newspaper which I knew was a preamble to something that was coming before me, I would turn to the next page. It's idiosyncratic, I appreciate that, but the purpose was, for me, that when I came to look at the matter in a focused way, I did so solely on the basis of the papers that were put before me in legal argument. There's also, of course, built into that, the question of our own ideologies. All of us are rooted in our own ideologies. Some of us are conservative by nature, some of us are more liberal by nature. But that doesn't mean that we have the opportunity simply to give vent to our ideologies. The question then becomes, how do you ensure, as best as is possible, that you do not become a victim of your own ideologies, especially when they are unconscious? We all know, you can say to anybody, what would you do there? Would you take a particular ideology into account? And they'll say no, and yet they may unconsciously do so because it's built into their nature. The way I approached it, and the way other judges I am sure have approached it, is to look solely at legal arguments, to look solely at what the law provides, what the facts of the case proven by evidence provide, and then to come to a legal decision. On that basis, those unconscious ideologies find barriers in their way. I'm not saying that that proves itself absolutely. I'm sure all of us from time to time are aware of judges who are known to be conservative, coming out with conservative judgments. Indeed, in America recently, the whole issue of the appointment of a new Supreme Court judge has involved exactly that issue. The issue of media pressure, which I've also been asked to look at, was perhaps more complex. In determining basic law matters, I quickly became aware of the fact that following my judgments, I had to expect not simply press analysis, I had to expect criticism from unsuccessful parties or interest groups or crusading newspapers. Increasingly, and this I think is going to be a matter which will have to be dealt with by judicial authorities in the years ahead, increasingly I also became aware of the fact that from time to time individuals would use social media platforms to pour out a lot of venomous criticism. With some pride, I like to think of the fact that I have, in my time as a judge, been labelled first a stooge of the government, being paid money so that I can buy myself a retirement mansion in the United Kingdom, where I have no intention ever of living, but that's beside the point. And equally, I have been branded a dangerous liberal influence determined to undermine the roots of legitimate government. So I was damned if I did and damned if I didn't. And I think that a great many judges will share that view with me. I myself didn't know about the workings of social media, and so these various venomous attacks on various platforms I was ignorant of. But there's always somebody who will bump into you in a shopping mall and say, have you seen this particular website? You should read it. It says awful things about you. And all of us are so weak that, of course, we do exactly that. Let me pause to say, if I may, that these troll attacks, and I think that's exactly what they are, can be dealt with by engagement, but common law judges speak through their judgments and otherwise they remain silent. In that particular area, therefore, to go and engage would be entirely wrong, and indeed, in my view, entirely self-defeating. Such attacks can, and no doubt do, constitute a form of contempt, and the more serious, the more threatening, the greater the contempt. The issue, however, is, I think, that, again, by engaging with them, you simply give them exactly what they want, and that is some notoriety. For myself personally, therefore, never fearing what was coming or what the consequence might be, other than vitriol, I adopted the tactic, as all other judges I know have done, of ignoring them. Aside from these things, however, let me emphasize that all judges are fully supportive of informed public debate. Freedom of speech is integral to Hong Kong society. The judgments of our courts can have profound effects on the workings of society, and they must therefore be open to rigorous debate. What falls from the lips of judges has no special sanctity about it. Nevertheless, from time to time, criticism does hurt. It does sting. All of us, I think, have a degree of self-esteem. All of us are happy with praise. None of us are too happy when we're told that we have gone grievously wrong. I have spoken of being stung, and this has, I think for most of us, greater strength where the criticism, not being legitimate, has been misinformed. In order to try and avoid this, therefore, I adopted two ways of attempting to deal with the matter. First was to seek always clarity and simplicity of expression in my judgments. A friend once said to me, "I don't agree with your judgment, but at least I understand it sufficiently to know why I'm disagreeing." Accordingly, it became my practice to write and rewrite single paragraphs, if necessary, a number of times. Plain language is not always absolutely possible, but accessible meaning must be. In addition, if a case was running for several days, by reading the newspaper in the morning, you could sense that there was an emerging misunderstanding, perhaps, of the issues. And on such occasions, I would do my best in my judgment to set aside those misunderstandings by plainly spelling out what the basis of my decision was. If necessary, in an early paragraph or two, and I often found this helped, I would state what the case was not about. Informed, temperate criticism, therefore, is never of any real concern. As the saying goes, it goes with the territory. What must be remembered also, I think, is that judges in the common law system are trained to a system of constant review and constant criticism. When they take the judicial oath, they know that everything that falls formally from their lips, literally everything, may be subject to criticism by way of a higher appeal or by way of some form of review. Criticism, of course, as I have tried to emphasize already, should not be blown out of proportion. I would add that as far as judges were concerned, the ones I worked with and myself, in writing our judgments, we felt very little, if any, form of external pressure. There was one occasion when I wrote a judgment in respect of a matter, and there was at the time a public march taking place to object to exactly what I found to be the case, and one of the people in that public march was a retired judge. Afterwards, people said to me, "How was it that you were not influenced by that?" And I said, "Well, I'll tell you why, because I was in my study writing the judgment and I didn't know it was taking place." But even if I was aware of it, I think judges in Hong Kong know that they have no reason to try and meet expectations of any particular section of society. The expectation they're looking to is a judgment that speaks to the truth legally. Judges are not, for example, in Hong Kong, as they are, for example, in certain parts of America, elected to office. They are not, therefore, like politicians who need to obtain partisan approval. Hong Kong judges are appointed, and this is an important issue, by an independent committee which ensures that judges must be individuals of integrity and ability based on appropriate qualifications. When they assume office, therefore, Hong Kong judges, as servants of the community, are aware that they have been accepted as men and women of integrity and that they are expected to act in that way. An expectation can be a very palpable thing. When you know you have to live up to a reputation, when you have to live up to a responsibility, it can be a great urging principle. I have touched, or will touch now, on the elusive topic of the rule of law. Different countries have different traditions and experiences. The rule of law, therefore, is not in every facet the same in every jurisdiction. I believe it to be universally effective, however, in the following way, that the rule of law demands that all persons, without discrimination, are entitled to a fair hearing conducted by a competent and impartial court. An impartial court is one which decides cases without prejudice or favor. A competent court is one which has the integrity to do so. So much is fundamental. What I believe is equally fundamental is that if judges are to be able to meet these fundamental obligations, they themselves must be protected. Alexander Hamilton, one of the founding fathers of the United States, famously wrote that the judiciary was the weakest of the three departments of government. It had no influence either over the sword or the money purse. Accordingly, as he went on to say, all possible care must be put in place to ensure that the judiciary is protected against attacks from every quarter, including attacks from the executive and the legislature. In Hong Kong, that protection exists and is inscribed in law. First, judges have no fear of dismissal. They have security of tenure until a mandatory retirement age or the expiry of a fixed term. Second, disciplinary action against judges, as rare as it is, and in my time, mercifully, I have no knowledge of any such action. Such measures are regulated by clear and precise principles. Third, judges have at all times been appropriately remunerated and have been given an adequate pension. During my term as a judge, the Hong Kong government, at a time of particular economic crisis, when other arms of the public service were taking pay reductions, accepted that it would be wrong in principle to reduce the salaries of judges. Fourth, within the judicial system, the distribution of cases has never been politically influenced. There is nobody there to say, this is the man here to hear this matter because he's going to come up with a particular result. Fifth, and finally, judgments once given remain of effect until or unless they have been subject to revision by set procedures of appeal. In my experience, therefore, these measures result in what I started out with, namely that politically sensitive cases are no different from any other case which is sensitive to particular complex issues, and any pressures from any partisan sections of the public can effectively be ignored. Thank you.
Thank you very much, Ms. Justice Hartman. That is a very, very revealing presentation on how the system of justice works in Hong Kong. It seems that a lot of overseas media has reported Hong Kong to have lost judicial independence, imagining that the judges are now under the influence of the National People's Congress or some external influence. And that is really not true at all. And we can assure you that, in fact, there is no truth in those allegations at all. Now, The next speaker is Professor Nicole Shriver, also from the Netherlands. Professor Nicole Shriver is an international lawyer, is a very prominent international lawyer, as well as a statesman. He is a member of the Council of State, State Councillor of the Council of State of the Netherlands, and he has also published extensively on public international law and has written a lot about the United Nations. Professor Shriver is a professor of international law at Leiden University and visiting professor EU and cooperation in developing countries at Université Libre de Bruxelles. Previously, he was a senator and chair of the Standing Committee on Foreign Affairs and also served as the president of the Academic Council on the United Nations System, the International Law Association, and the Institute of International Law. And he has published extensively on public international law issues, and also he is a member of the Permanent Court of Arbitration since 2007. So without further ado, may I hand over the time to Professor Shriver.
Thank you, Madam Winnie Tan. Good afternoon or good morning to some of us. It's a great pleasure to participate in this vibrant rule of law gathering in Hong Kong, and I regret that I cannot be physically with you and only speak to you remotely. However, I'm grateful for the opportunity to provide you with some information on the way my country, the Kingdom of the Netherlands, has responded to the COVID-19 emergency and the challenges the Netherlands, as so many other countries, faced in balancing between the need to divide an effective response to the pandemic with preserving the rule of law. We had the first wave of the coronavirus during the period, let's say early March, July of this year. Unfortunately, a second wave emerged much earlier than anticipated, and it started to show its ugly head from late September on. As you may know, the Netherlands is a highly densely populated country with approximately 17 million people. I'm afraid that we score rather high on the world list of the number of positive tested persons and reported deaths as a result of the coronavirus. Somewhere around place 20, just between Turkey, the Philippines and Bangladesh, with so far a recorded number of 375,000 positively tested persons and 7,500 people who died as a result of COVID-19. From an early stage, the Dutch authorities aimed to go for a maximum control of the virus by adopting, on the one hand, a so-called intelligent lockdown, and on the other, emphasizing the self-responsibility of citizens. So first of all, we did not go at any time so far for a full lockdown, but for a selective one, a so-called intelligent one. The government did not impose a general stay at home for everybody and a total closure of all businesses. But of course, offices in non-essential sectors were closed, schools were temporarily suspended, and so were places of warships. They all had to go, nearly all had to go virtually. As I indicated already, the government made a strong appeal to the self-responsibility of citizens rather than imposing compulsory measures. All people were called upon to follow strictly the hygienic rules, avoid public venues as much as possible, and maintain a 1.5 meter physical distance. For long, face masks were not prescribed in either private life or in public places, but with the arrival of the second wave since October, this policy has been changed, and now there are mandatory rules for wearing a face mask. Obviously, access to justice in the usual way, for example, filing of complaints at courthouses, the legal proceedings there, were seriously hindered. Governance and democratic control through parliament, provincial and city councils were as much as possible maintained, and the institutions were fully kept in place. Personally, I was quite impressed by a joint declaration on 7 April 2020 by the 5 highest organs of the states. So the Speaker of the House of Representatives, the Speaker of the Senate, the Vice President of the Council of State, the President of the General Audit Chamber, and the National Ombudsman issued a joint statement. And I quote from it: "It is our common view that the democratic process should continue in its ordinary way, despite all restrictions emanating from the need to protect public health. This means that our 5 high organs of the state will try to function as optimally as possible during these months. Of course, where necessary and possible, supported by new digital information and communication techniques. Especially during challenging times, high quality advising, solid public deliberations and decision making, transparency, effective control over and accountability for the spending of public means, and an adequate assessment of the carefulness and the legality of state behavior should uninterruptedly and fully be guaranteed." End of the statement. From this start up till today, there was a deliberate decision not to go into a state of emergency, a possibility provided for in the Dutch constitution, but rather for a variety of ad hoc emergency legislation projects subjected to ordinary parliamentary scrutiny. Obviously, this has proven not to be without challenges, but I do believe that somehow a balance could be maintained with a specific role of all organs within the trias politica, consisting of the 3 departments: the executive, the legislative, and the judicial powers. In the case of a nationwide outbreak of an infectious disease, there is a central role for the National Institute for Public Health. It provides the statistics and the expert advice to the government. And this institute works closely with the World Health Organization on the one hand, but on the other also with municipal public health services, with experts, with representatives of the hospitals and various other organizations. And this institute also convened a so-called outbreak management team, in which, apart from virologists, a wide spectrum of other experts and disciplines were represented. On a weekly basis, they meet with our cabinet and they provide the advice directly to the government, and they also inform Parliament, and on this weekly decision-making is built. As regards the rule of law, in an early stage, legislation was adopted to replace physical court sessions by electronic ones in civil, administrative and criminal law proceedings. In certain cases, particularly criminal law cases, physical sessions could not be avoided so as to guarantee the principle of due process, public access, for example, also to allow for victims' participation. Hence, the principle of physical sessions was maintained in these cases, while acknowledging that public health, a good administration of justice, you can't suspend proceedings for too long, and public order may justify limitations to openness and public accessibility. In a similar vein, various court terms, deadlines for decisions on complaints, and appeal terms of, say, normally 6 weeks, were now extended till 12 weeks. It was also emphasized that all these emergency procedures were of a temporary character. In principle, mostly for half a year, with the possibility for an extension of 3 months if necessary. As regards meetings of public organs, such as Parliament and city councils, the starting point remained physical sessions, once again in order to guarantee transparency, public access, public participation, but arrangements were made to meet in a virtual way and even to vote electronically by digital means if necessary. Of course, with the exception for confidential voting, for example, on persons for certain functions. The Council of State, the principal legal advisory body of the government and parliament, on which I serve as a state councillor, was deeply involved on advising on all kinds of bills and regulations, as well as on issuing advisory opinions on request of either the government or one of the chambers of parliament. Let me mention, by way of example, the advisory opinion on the constitutional dimensions of crisis measures. In this opinion, we spelled out how democratic procedures should be maintained as much as possible and with parliamentary control. We also addressed the sensitive issues of limitations to the exercise of civil rights freedoms, both in public and private life. Obviously, we could note that sometimes freedom of demonstration and even the freedom of religion, of worship, had to be balanced with the need to maintain public health, public order, for example, by observing physical distance of 1.5 meters, and that sometimes is impossible during demonstrations. In the view of the Council, necessary exceptions to and limitations of fundamental rights and freedoms can only be justified if they are based, first of all, upon a prior law, the principle of legality. Secondly, if they are really necessary, and thirdly, if they are proportional. And these are cumulative and not alternative requirements. All these issues also came to the fore in the legal regulation of the law on contact tracing, popularly known as the Corona app. On the one hand, potentially a very good device in tracing the origin of the spread of the virus and alerting people, but it also raises a host of issues as regards privacy and data protection. We also addressed the issue of emergency ordinances to respond to crisis situations, for example, also by the 25 safety regions in the Netherlands, which are headed by the mayor of the largest town in that region. The Council of State strongly advised that these emergency ordinances would always be of a limited duration and need to be replaced by ordinary laws in order to have a solid legal footing. Parliament itself has demanded in October that such emergency ordinances should always be submitted to Parliament for approval or disapproval within 1 week. There is a strong feeling that the democratic process should remain intact and that democratic control is also essential for generating public support for the restrictive measures which have to be taken. The Council of State also made a plea to always provide for a solid evaluation of the law at regular intervals. Well, for reasons of time, let me wind up, Madam Chair, and with this, I hope to have provided you with some insights how the Netherlands, as a country far away from Hong Kong, but we are on one globe, as the virus demonstrates, how my country has responded to the COVID-19 pandemic and managed in seeking to balance between the goal of protecting public health and preserving democracy, the rule of law, and respect for human rights. Thank you very much.
Thank you very much indeed, Professor Shriver, for sharing the Dutch experience from the point of view of a statesman and also a professor of international law. Can you hear me? Thank you very much, Professor Shriver. It was very interesting to hear your point of view as a state councillor. So we see that the entire government, all the three branches of the government was at work, not just doctors and nurses in this crisis, to uphold the rule of law, maintain legality in emergency legislations, and all the measures imposed on its people in these extraordinary circumstances. Now, we have come to a Q&A session, and I have in my hands a number of questions directed at speakers. The first question is for Judge Sher. Madam Judge Sher. This is from the audience. Now, you mentioned that in handling political issues, judges will look at the legal aspects. However, that may not offer a full solution to a politically related dispute. In that case, after receiving a judgment from the court, what is the next step to the dispute? Madam Judge Sher, could you respond to this question, please?
Thank you. That's a very good question. You know, first of all, as I said, that for the court, its function to settle the legal aspects of the dispute that is brought to the court. As to the implementation of the judgment and ultimate solution to the overall dispute between the parties, that does not fall within the mandate of the court. And you're absolutely right that many a time when a dispute is submitted to court, the dispute itself may only represent one aspect of the overall context. You may say the overall bigger picture. But it's not up to the court to decide whole, let's say, the whole matter. The court's responsibility is only to address the legal aspects. And for the implementation of the judgment and for the overall situation, it's up to the parties to decide. And sometimes the case may fall within the domain of the Security Council or the General Assembly. That's my answer.
Thank you very much, Judge Shi. Indeed, I mean, the court could not see through the implementation of the judgment. The next question is for Justice Hartman. One member of the audience asked, with the attack sometimes without grounds, unjustified attacks on the judiciary and the judges due to individuals' political stance, what advice would you give to those who aspire to join the judiciary?
If you yourself are a political activist, if you have very strong views which you like to voice, if you want the honest truth, I'd say don't become a judge. I feel strongly that judges, when they judge a dispute, must be seen to be neutral. And I think that if a judge has any well-known, indeed notorious, and it would quickly become notorious, political views, all too often in the eyes of litigants in any event, those views will color the outcome of the dispute. The fact that judges get attacked from time to time obviously will vary depending on the type of judging you do. If you are in a technical area, you may get attacked in maybe technical journals, but you're not likely to have people on the pavement shouting at you. What I would say is that there are many occupations where you must expect criticism. And judging is simply one of them.
Thank you very much, Ms. Justice Hartman. It seems that a lot of times when we see a personal attack against judges, it is really not an intention to attack the judge, but not so much that, but really a way of venting anger in a highly politicized society. That seems to be the case all the time. And I think, unfortunately, judges in this kind of environment will have to psychologically prepare themselves for this kind of attack and be able to feel immune from it to a certain extent without allowing it to push the judge to the other end of the political spectrum, which would be highly undesirable, it seems.
Yeah, if I could just add one thing there, that this not only applies to the English common law. I think there are novels in many languages going back a couple of hundred years of frustrated litigants, and we would call them vexatious litigants. They often become emotionally unstable, and that emotional instability may lead them to fairly venomous attacks. Again, it's simply part of the job, if I can put it that way, and if it's too dangerous, then you can seek assistance.
Yes, thank you very much. I have a question which could be open to all three speakers. It has been said that because judges or the judiciary as a whole very often come under attack for political reasons often, is there a way to improve communication between the judiciary and the people in general outside the rendering of judgments? Is it desirable, for example, for the judiciary to have its own communications department? What are your views?
My view is clear. The answer is no. As I said earlier, judges speak through their judgments and otherwise remain silent. I think if you see an efficient, competent, honest judiciary going about its day-to-day work over an extended period of time, that will speak volumes much more than what may be seen as propaganda from the judiciary.
Very well. Any other views from the two speakers in the Netherlands? Madam Xu?
Yes, I agree with Judge Hartman. I think for the judiciary judges, maybe at the international level, things are quite different from domestic level. And I think people or states, governments, expect that court will deal with highly politically sensitive cases, because there are cases
Madam Justice Xu, I'm afraid we couldn't hear the last 30 seconds of what you were saying.
Yes, I'm
now
sorry.
we can hear you.
I have to say, at the international level, things may not be the same as domestic level. And the public may not be as sensitive to the cases or the judgments as those at the domestic level, because they are a little bit remote from what's going on. But that could be the case with the country that a party in the case. But even so, I think for the judiciary, we just do what we are required of to really adjudicate the case in accordance with international law on the basis of evidence of facts. But of course, we are expecting, we have been criticized by the public or by some country for the judgments. We accept it in the sense that this is part of a job. As to whether court should go to the public, how to build up the relationship, I doubt that we can build up that kind of a relationship. What we have to do is do a good job, in the sense that to deliver good, sound judgment, well-reasoned judgment. That's our job. Thank you.
Professor Shriver?
Thank you. Yes, well, I fully agree with the two judges that judges cannot be expected to engage with the public and should also not do so. These judgments are not a matter of negotiation. However, I think there is a very important complementary role of Parliament and government. First of all, in guaranteeing the independence of the judiciary by lifetime appointments, by an adequate salary, as Justice Hartman pointed out, but also by making judgments public and by making the outcome of the judiciary open. So I think principles of openness and transparency and accountability for the way the judiciary is organized rests with the government and Parliament. And of course, the Parliament and as the democratically elected persons and the government really have to engage with the public as opposed to the judiciary. I think that providing access to information, public participation in consultations, in decision making, transparency, being accountable for the decisions to be taken are extremely important to have public support for measures to be taken, including the way the judiciary functions.
Thank you very much. Those are very valuable views indeed. One more question, and possibly the last or penultimate question, which is for Professor Shriver. You mentioned that public health is an exception to the enjoyment of civil rights. Now, if this position is correct, a member of the audience wishes to know, how do we strike a balance in pursuing civil rights without delay due to the pandemic?
Yeah, well, indeed, in our constitution, we have some limitations to the exercise of civil rights. For example, freedom of demonstration, freedom of religion, freedom of movement, apart from security and public order. Public health is also mentioned in our constitution for a long time as a ground upon which you can restrict civil rights. However, that, as I stated, has to be based upon a law. In this particular case, the law on public health, which is a direct implementation law of the International Health Regulation of the World Health Organization. And as I mentioned, you have to be able to show, as the executive, that this is really necessary, that for reasons of public health, you can't have a demonstration on the inner square of Parliament or in front of the Royal Palace in Amsterdam, since people do not maintain a 1.5 meter distance. And of course it has to be proportionate. You can suspend such a demonstration for that particular afternoon, or you can say not this week, but you cannot just say for the next year we prohibit all demonstrations. So in this way, you have to dance on the very thin line of the court of maintaining, on the one hand, public order and promoting public health, and on the other, of course, respecting the rule of law.
Thank you very much, Professor Shriver. I believe proportionality and balance are the most difficult issues for each government around the world in these very difficult times. Now, time has come to 6:10, and I'm told to round off with this wonderful panel. Thank you very much for the two speakers from the Netherlands, from The Hague and from Leiden, right? And also thank you very much, Ms. Justice Hartman, for joining me in Hong Kong. We have had a very meaningful discussion on how different authorities and courts around the world, including international courts and national courts, have risen to the challenge in trying to deal with emergency situations and to try to balance civil rights against the needs for health and safety in these very difficult times. And we've heard judges sharing experience on dealing with politically sensitive cases, both at the international court level and in the Hong Kong courts. And I hope the audience will go away with the clear idea that judges do not carry a kind of its political beliefs in judging cases, not in Hong Kong and definitely not in the ICJ. And on that note, I would thank again all that have attended this session. I was told that there has been around 1,000 people online, and that is a very, very good number, very encouraging indeed. And thank you again for spending the afternoon with us. Goodbye.
Thank you very much, Ms. Winnie Tam and Mr. Justice Hartman, who joined us here today in Hong Kong, and Judge Su and Professor Shriver, who joined us online for the intellectual discussion, especially sharing their experience on these complex and sensitive issues. For our closing session, we are most honored to have invited the Honorable Mr. Justice Andrew Cheung, the permanent judge of the Court of Final Appeal, join us virtually to deliver the closing remarks. Mr. Justice Cheung, please.
I'm honored to be invited to give these closing remarks for the inaugural Rule of Law Congress held this afternoon. The rule of law is, of course, a big and important topic. Lord Bingham concluded his celebrated work, the rule of law with these words. The concept of the rule of law is not fixed for all time. Some countries do not subscribe to it fully, and some subscribe only in name. If that, even those who do subscribe to it find it difficult to apply all its precepts quite all the time. But in a world divided by differences of nationality, race, color, religion, and wealth, it is one of the greatest unifying factors, perhaps the greatest, the nearest we are likely to approach to a universal secular religion. It remains an ideal, but an ideal worth striving for, in the interests of good government and peace, at home and in the world at large. In these closing remarks, I would only like to make a few observations on the meaning of the rule of law as practiced in Hong Kong, looking at it from the perspective of the courts, which, as all would agree, play a central part in upholding the rule of law. First, what are the aims of the rule of law? What do we want to achieve by insisting on the rule of law? From the court's point of view, the rule of law ensures and promotes fairness, equality, and justice, which are the core values of the administration of justice in our system of law. These objectives are reflected in our case law and our procedures. Thus, the courts insist that everyone is subject to the law. Nobody is above the law, and everyone is equal before the law. There must be neither favoritism nor discrimination. In Hong Kong, we have a vibrant public law regime, which is found only in advanced common law jurisdictions, for the purpose of ensuring that the government and other public authorities operate within the law, and public powers are exercised in accordance with the requirements of the law. Furthermore, the courts requires that laws must be published and generally accessible, and the courts proceed on the general basis that laws should not be retrospective and they have to be certain. For those who subscribe to a substantive or thick concept of the rule of law and consider that laws must be just and must protect and uphold fundamental human rights, they can easily see from our judicial decisions that the courts generously interpret and jealously guard the fundamental rights of all people in Hong Kong, which are guaranteed under the Basic Law and the Hong Kong Bill of Rights. Secondly, the rule of law comes with a price tag. The insistence on the requirements of the rule of law, the strict adherence to procedural guarantees on fairness of the legal process, and the equal treatment of each and everyone who comes before the court necessarily mean that even the rights and interests of the unmeritorious are safeguarded. And indeed, they are safeguarded in no different way from those of the meritorious. They must also mean that legal proceedings take time, and sometimes much time, to proceed and conclude, as much as we want to speed up the hearing of cases and appeals. The holding of the government to legal accountability means that delays, and even substantial delays, may be caused to the implementation of government decisions or projects, no matter how important or desirable they may be for the public good. All this represents the price society has to pay in order to maintain the rule of law. But not only that, in a society governed by the rule of law, members of society must learn to accept that from time to time, the outcomes of judicial proceedings may not be to their liking or accord with where they consider justice lies. Indeed, one may say that a good way to measure how entrenched the rule of law as a core value is in a society is to ask how well its institutions and its members are able to accept and respect unpopular judicial decisions and the judges who made them. Hong Kong prides itself as a society governed by the rule of law. The continued validity of this claim is dependent upon the willingness of our community to pay the price that comes with upholding the rule of law. Finally, what makes the rule of law work? One important requirement is that we have judges who are independent, impartial, fearless, and competent, and we need to have them in sufficient numbers. Aaron Barak, former president of the Israeli Supreme Court and a renowned jurist, wrote in his thought-provoking work, The Judge in a Democracy, that I do hope that the judicialization of politics will not increase the politicization of judicial appointments. On the contrary, it should reduce such attempts. If politics is judicialized, what is needed is objective, professional, and independent judges. That calls for less politics in the appointment of judges. It seems to me that the trend is toward more professionalism and less politics. In Hong Kong, Article 92 of the Basic Law specifically provides that judges are to be chosen on the basis of their judicial and professional qualities. There can be no compromise on the qualities required. There should be no politicization of the appointment process. Equally importantly, it should be pointed out that a prolonged inability to fill judicial vacancies may become a latent threat to the continued maintenance of the rule of law. The legal profession, and indeed our community, should actively encourage lawyers of the requisite qualities to apply to join the bench. A society which embraces the rule of law expects much of its judges. The other side of the same coin is that a society which treasures the rule of law treasures its judges. A society which protects the rule of law protects its judges. In Hong Kong, we take pride in the fact that judicial independence is not only constitutionally guaranteed in the Basic Law, but is also practiced on the ground. Nonetheless, constant vigilance is required to protect judicial independence. And that is a responsibility of everyone who wants to see the rule of law continue to flourish in our society. On their part, our judges must remain faithful to the solemn judicial oath that they have all taken. Our courts must continue to be manned by judges who are impartial and objective, dedicated and professional, judges who see the upholding of the rule of law and the due administration of justice as their mission and responsibility. Whilst there is always room for improvement, I have every confidence that our judges will continue to play their important part in maintaining the rule of law in Hong Kong in future, just as they have done in the past. Thank you very much.
Thank you, Mr. Justice Cheung. This officially closed the inaugural Rule of Law Congress. A special thanks to our speakers who joined us here physically and speakers who join us virtually, and the participants that are watching this live broadcast. Thank you very much. Please do join us again tomorrow for another Hong Kong Legal Week event, the virtual edition of the 14th Annual Generations in Arbitration Conference at 9:30 a.m. Thank you and have a good evening. Goodbye.